version.
All right,
What's
it's March 12th. So we are taking up JRS 15. We have elected council with us. There was one small change I have made at the very end of it. Elected council will walk us through. Yes, the floor is yours. Thanks.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and we're looking at JRS 15. So usually you don't have your regular counsel on these, but sometimes you do with regard to policy resolutions. And I've done a couple of these before, so I'm doing this one. It's just a policy resolution stating Vermont's commitment to supporting the Vermont's non-binary and transgender community, identifying a few areas in existing law where Vermont has anti-discrimination legislation, protecting gender identity in the law. Does not change the law in any way, just as a reaffirming Vermont's commitment to treating everyone with respect and dignity. So there is, as the chair mentioned, there is a small amendment that you have. And all it's doing is that in the last resolved provision at the very end, where currently in the bill, as in the resolution is introduced, the Senate Secretary is directed to send a copy of the resolution to Outright Vermont and the Pride Center of Vermont, but also as the congressional delegation.
Thanks. Any questions, comments? Rest of section.
Pardon?
Oh, it's been said.
I'm glad that we added the congressional delegation.
And that was a recommendation from Senator Lyons. Just to give that shout out. I guess. Okay. Everybody understand resolution? Also, yeah. All right. Okay, well, if there's no additional discussion or questions, if you look like 160.
Yeah, my only question, and it's simply because I don't know, and I don't actually expect Michelle to know the answer. I certainly recognize the Pride Center and Outright as being two of the organizations that support our LGBTQ individuals. I wonder if they are the only ones, or if they are statewide. I wonder if it's inclusive of everyone that should be made aware, if that makes sense. And I don't know the answer. Yeah.
I don't know the answer either. I'm sure there's many organizations that in various ways support LGBTQ folks, but I don't know how much we're going to necessarily add to this list. Those are the two organizations that at least I see often in the State House. I'm not sure of any.
They are usually the two that are included when we do, committees that touch on this area. They're usually the ones that are given name response.
I just wanted to make sure that because I see them all the time. I'm in Chittenden County. I wanted to make sure we were sort of wide inclusive and not forgetting anyone. I don't feel strongly. I just wanted to make sure.
Yes.
Raise the question of, is this inclusive?
Committee, anything further?
Or if you would entertain a motion, but I would move that we pass the resolution favorably as amended.
So with whatever the amount of words. So, is there a second? We need a second.
I don't think we need a second.
No. So Senator Matt, any further discussion? Senator Mattis.
Senator Norris.
Yes.
Senator Bihowski.
Yes.
Senator Baru.
Yes.
Senator Matos. Yes. Senator Hersheen.
Yes.
5-0-0.
Here, I was just going to say, so Senator Mattis just pointed out that I have a little typo in there. So there's a space missing. I just added it. I'm going to send a new copy with that space to Kayla, but should I send it out to the whole committee or?
think we'll survive.
Okay.
Yeah.
I feel perfectly okay with you adding the space.
Oh, yes, all right.
I give props to Kayla. She was the eye on that one.
All right, awesome. Thank you, Gayla.
I can, report that out once we, get a clean copy of it. I'll bring it up. Oh, Michelle, we have a few minutes. Do you want to talk about the change that we made in SA7?
The one I just spoke to you about? Yes. Okay, sure. So I, just when you guys switched to the other issue, I wrote up your amendment for SA7. It's with, editing now, but something that I just kind of added on my own, but checked with the chair to make sure it was okay, is that so you have, in the bill it's introduced and you didn't change it, you have an effective date on passage. And I added clarifying language that the changes apply prospectively and are not to affect any pending extraditions. So you recall that, you have a provision in Title I as well as some constitutional protections around when you're making amendments to the law. If you have like a pending case or somebody has something going on that you don't want to kind of interfere with that and change the rules of the game essentially. So if someone is operating under the current system where there's a 30-day plus the ability for it to have a 60-day extension, you've got 90 days. So if they're kind of in the middle of that, and then you change it, I think it gets a little messy. So I think it just because you could have someone who has an expectation that they have a 90-day limit, and then all of a sudden you're changing it where there's the 90 days plus the 30-day extension to 120 days. So I wasn't that.
Committee, how do we feel about S87 in general? Extradition bill?
I'm okay with that change. I'm good with it.
I'm okay with the change. I'm a little ambivalent about the bill and I do still want to chat with the AG's office. Into which just to kind of, as you know, we sort of started a conversation before we went live and I'd love to finish that.
If we could have it, if we've got time tomorrow.
Did I see the floors on one?
For if that'll end next week, 17th.
Next.
Except for Tuesday, when it's at, the 9:30.
Yeah. See if it comes.
That's all right, we only announced.
15 minutes.
Last night.
On F87,
I think Ashley sent out.
tomorrow morning.
Yeah.
And we'll also probably put it up for a possible vote.
What's that?
As well.
The 7 days.
Sounds good.
I know.
I'll send a copy of the edited version of the amendment to Kayla so that whenever you guys, if you want to take it back up, you can do that. And then also, just to let you know, as I did let Todd know, the AG's office know about the prospective application and just check and see if any concerns. He said he didn't, but he would have to check.
That's good. Thank you.
Still shaken by that space. The space.
It takes a village.
Now I'm-
to get
Well-
the legislation. I appreciate all the.
So we start with our miscellaneous bill a few minutes early. Don't have Eric here yet, but
I think he's on his way.
that's wonderful.
Mr. Chair, I sent you some language. For the bill, have a look at.
Yeah, I did see that. I think Sarah Robinson is joining us a bit later or shortly, and let's go down the list. We have James with us, or Bob will give you. Oh,
He's supposed to be 3 months old.
Checking after just graduated.
okay,
Wait. He's online.
okay, great. Mr. Knapp, can you hear us?
Yes, I can.
Good morning. So our election council isn't here yet, but we are happy to take your testimony about our bill, miscellaneous bill.
Okay,
Yeah, the floor is yours. I introduce yourself.
all right. For the record, my name is James Knapp. I go by Jim. By way of background, while I'm scrolling down to find the section that I'm talking about, I am a happily retired attorney with 42 plus years experience in property law, 25 years of that in private practice, 10 years with title insurance companies, 2 years with the tax department, couple of years with the Bar Association. Typically what my best friends say is one of two things. Either he's led an interesting life and has had many jobs and learned many things, or geez, I could have the job. So we are, I am here to talk about section 16, 27 VSA 348, the new language that's being added in section F, which appears on page 14, starting at line 16 of the bill. And this is a provision that's proposed to fix a problem that occurs because section 305 of Title 27 specifies that in order to use a power of attorney to sign documents related to a real estate transaction, so a deed, a mortgage, a lease, anything that affects real property, the power of attorney has to be executed according to the law, but the section also says the power of attorney has to be recorded in the land records where the documents that were signed under the power of attorney are recorded, which makes sense. You would want to be able to find the power of attorney to be sure that it was properly signed. We've had a couple of different methodologies for signing powers of attorney. And you would want to be sure that the power of attorney covered the specific rights. So if the agent used the power of attorney to sign a deed, you'd want to be sure that that was covered. If the agent used the power of attorney to sign a mortgage and a note, you'd want to be sure that was allowed under the power of attorney. The problem arises historically that although people in the real estate world generally try hard to do well and do this, periodically the power of attorney either never makes it to the land records or, unfortunately, may be misindexed in a way that it can't be found. So both of those become issues because a title examiner looking at that title years down the road knows the law says you have to find the power of attorney in order to validate the signature on the document. And woe to you, you can't find the power of attorney, which calls into question the validity of the deed, mortgage, lease, whatever you're looking at, because you can't find the power of attorney. So this has happened to me a few times in private practice. It was a much more common, though not like an every week occurrence, when I was an underwriter for a title insurance company, actually 3 different title insurance companies. And the question becomes, well, what can you do? And the answer is nothing. Either the title insurance company takes a risk and says, look, we think the power of attorney is probably there, so we're going to ensure the title's okay. Or everybody goes, oh my God, we got to fix it. So now you go find a lawyer who's been retired 10 years to see if they still have their files in a barn somewhere that still has the power of attorney in it, so you can record it and validate your chain of title. This section, as Eric explained, I don't know if he's there yet or not, because I'm looking at you and not at the screen that has your system on it. As Eric explained, the idea here is that after the passage of a period of time, we shouldn't be so concerned about the missing power of attorney. If no one has raised the issue that the documents weren't validly signed, filed a suit to quiet title, filed a suit to eject the legal process for removing somebody who shouldn't be on your property, the people who are there, we should just let the problem lie and we should say it's okay. That's what this section does. It says that if the instrument signed under a power of attorney has been on record for at least 15 years, then the document is valid even if the power of attorney can't be found. There is the limiting section that says that if there's already a lawsuit involved, this section won't undo that lawsuit. That lawsuit will run to its conclusion. If you look back in the remainder of section 348, which I think it was great that that was included because it gives you context, you'll see that there are a whole series of things that are corrected by the passage of time. Specifically in section A, there's a whole bunch of technical elements that are fixed after 15 years. The most common one that's actually applied to is the fact that the document was either not acknowledged or was not correctly acknowledged. That's a big issue in the bankruptcy court involving mortgages. That's a 15-year statute. Starting in around 2004, a series, well, I don't know if you call two things a series or not, two additional sections were added with a slightly different wrinkle. They typically looked at a 3-year fix instead of a 15-year fix. And I was watching the original hearing on this, and I believe one of you asked the question, why 15, why 3? Well, 15 years is a typical statute of limitations. You'll find in Title 12 that there is a provision that says you must bring an action related to the possession of real property within 15 years of when the action arises, or you're barred. And so that's where I assume, I don't know, the original Section A was adopted well before I was born and certainly before I started practicing. But I'm assuming that's why the 15-year target there, because they were looking at that 15-year period as being something that your predecessors in the legislature considered and decided that 15 years was a good period. I do know that the 3-year period that you see in some of the other corrective provisions in the statutes comes from actually our close relationship with Connecticut. The proponent of these sections was Liz Smith's predecessor at Connecticut Attorney's Title, Andy Michael, and he had a solid connection with the legal team in his home office. And in Connecticut, many of their corrective statutes only require the passage of 3 years before the corrective action takes place. How they picked 3 rather than something else, I don't know. I only know that that's the history. So with that, that's what I had to say, but I'm happy to answer questions if I can, if you have any.
Thank you. Committee, any questions? Senator Maddox, I know you're the reporter of this one. No, yeah. Okay. Want to make sure you're good. Thank you, Mr. Knapp. We do have Eric with us now, so I also know we have a few other folks. I believe we're here to testify on the same topic, but since we have Ledge Counsel here now, I want to shift gears, provide him with the time to speak on some of the other changes that we've made. that sound good, Eric?
Sure, whatever works.
Sounds good.
Morning, everybody.
Morning.
Eric Fitzpatrick, as the chair said here, from the Office of Legislative Counsel to talk about some possible additions and changes to S-109, the annual miscellaneous bill. So there is and this sort of stems from some of the conversations that the committee had last time about potential pieces to add. You may recall that the committee was sort of talking about that question of what might some additional sections to the miscellaneous bill be. And so they should have, I think, Gail passed out to you a proposed amendment that has a few possible additional sections for the committee to consider. In addition to that, after I describe those, I do want to mention also a possible change to one of the existing sections of the bill that's not actually in the amendment that you're looking at now. So having said that, let's do a walkthrough of what the possible additions are. You see that there's 1, 2, 3, 4, I think we have 6 different proposed sections to add. I will start with on page 1, section 19. This is a request from the judiciary, from the court to add this piece. It's really a technical fix. I should say that for background, the rules of civil procedure provide that when someone is able to ask for attorney's fees in a case, the plaintiff files an action, they're able to ask for attorney's fees. There's a provision that specifically says that if the amount of attorney's fees being requested is less than 2% of what the damages are, you don't have to have a hearing. Court can make a decision about whether or not attorney's fees are entitled and how much it's going to be without having a hearing. So this is just to make the statute consistent with that provision of the rules. You see that this statute seems to suggest that there always has to be a hearing. And this is with respect to a particular type of case, which is a mortgage foreclosure case. And this says, if you read the language, if there's a mortgage foreclosure case and claim is made for that in the complaint, upon hearing, the court shall allow attorney's fees. So the idea is to make that 2 provisions considered. So you would still have the rule applied, which is that if they're asking for 2% or more, I think it's 2% or more than 2%, but one or the other. If your attorney fees request is for more than 2% of the judgment, you would have to have a hearing because the rule says that for all cases. This is just making clear that that rule is going to apply to all cases, even these ones. So as I say, that was a request from the judge. The next section is also a request from, although this is more of a request from Chief Superior Judge, but I think more in his role as chair of the Coordinated Justice Reform Advisory Council. The C that was established, and that's section 2's repeal. Essentially, right now you have this entity in existence, the Coordinated Justice Reform Advisory Council. You may well remember it. It was created just a couple of years ago in 2023. Originally, it was supposed to stay in existence, or is right now supposed to stay in existence until 2028. So 5 years. And I printed out the specs and I get you if you need it. What this body does is it records and makes recommendations on community-based programs consistent with Vermont's restorative justice policy. So the idea is a restorative justice concept.
Which draft version?
1.1, March 11th, 7:48 p.m.
It's just the
What
2
page
page.
are you on?
This is just the 2 page. Yeah. Line 1.
Line 14. Yeah, exactly.
Oh, there. Yeah, but at least, yeah.
Yeah. So this Coordinated Justice Reform Advisory Council is supposed to sunset in 3 years, 2028. So I say it has to do with restorative justice, makes recommendations, analyzes state restorative justice approaches, make recommendations. It also has, you may remember this, in the miscellaneous bill last year, I remembered it as I was drafting this. There's a provision that was clarified because one of the other things that this council does is it makes a recommendation to the Department of Corrections, because the DOC has a line item in their budget of not more than $900,000 for justice reinvestment too. So they have to have this in their budget every year. And one of the things this body is supposed to do is make a recommendation to DOC about what that line item should be and what it should be for. So that's the various responsibilities they have. That's one of them. just because I remember clarifying that was in the miscellaneous, but just maybe not the question.
Eric, I'd like to interrupt real quick.
Yeah,
Caleb, could you please ask Dr. Donay and Terry ourselves to come in or see if they're available tomorrow. After we deal with the attorney general who addressed that as well as some other stuff. I'll get more. Thanks. Please.
yeah, sure, no problem. So yeah, the proposal is to basically, repeal this body this year instead of in 2020. So that's the proposal.
And you did say that was from Judge Sonnen.
Correct. And I think also, he'll be able to tell you better, but I think also another member of the committee, but he's the one who forwarded it up to me and requested, yes. So that was section 20. So now we'll move on to section 21, dissemination of electronic case records. So, page 2, but this will require a bit of background, and this also was a proposal that came from the Bar Association, and in particular, the VBA Court Users Group. I spoke with Al Bean, who's an attorney, who's the chair of the VBA Court Users Group, and that's a group that represents the Bar Association and works with the court and the judiciary to try and deal with the electronic access, the Odyssey system, the electronic filing system, to try and work between the attorneys and the court to make sure that the electronic filing system is working as it should, and make improvements where necessary, that sort of thing. So what the proposal is here, just a moment of background, is what's intended to address, if I'm understanding it correctly. And actually, Mr. Dean actually mentioned that he could also testify if you want to hear more from him about what the issue is here. But the issue is that that if you are an attorney, for example, in private practice, let's say you have a criminal defendant, and you're trying to get access to case records for the defendant, maybe you want to think about whether you want to represent the defendant. You can go to courthouse, to the terminal in the courthouse, and you can look up the person's past criminal record. You can look up what other interactions with the court they may have had, what other relevant information you think might be useful toward either representing the client or deciding whether you want to represent the client. The issue is that you cannot have that access from your office, from your home, or you might be working from. You have to go to the court to get it. Interestingly, so there's two issues. That's one. Issue two, the sort of connected issue to that is some private attorneys, as you know, have a contract with the Defender General's office, and they are contract attorneys who also do criminal defense work. Those folks actually can get the online access from their offices from home to those records for those criminal defendants. But again, the private attorney who's in practice is representing them cannot. So you got those two, you might call distinctions, the different ways that private attorneys representing defendants are treated versus contract defendants, and having to go to the court to get it physically, which anybody can do actually, and can go to the terminal. And these contract attorneys also have the ability to do it from home or from their offices. So the idea, and this is, as a result of, if you look at the existing law, the reason for that, if you look at the existing law, which is page 1, lines 18 to 21, I remember, I think this was enacted in the early 2000s. It was, 20 years ago was when this idea of the potential for people getting court records online was first getting started. It's long, actually, in the history of this sort of thing. So it seemed like a lot 20 years ago, but that's a long time for this. So it's long before what's available now, that people can do everything remotely, was envisioned. And what it was saying at the time was, I remember working on it, it said, courts should not permit public access via the internet to criminal, family, or probate case records. The idea being they just trying to keep people from sitting at home and Googling people's names, finding out anything about them. See, that was sort of what was thought at the time. That's the issue, but that's a long time ago. Now, at least with respect to practice of law, a lot of the stuff, as the Odyssey electronic filing system suggests, is done remotely. Has to be, in fact, filings have to be made via computer now rather than via paper, unless you're pro se.
I can just add something to that, Eric.
Yeah.
Just for listeners in the committee, this process, so as people probably know, I am one of those contractors who's working with the public defender, but the process of getting access to Odyssey, it's not like Google, you have to submit your information, your bar number, and then you have to get approved by whoever is on the other end. After they verify all that information, so it's not like anybody can just say, yeah, I'm a lawyer, and then get access to Odyssey.
Right.
So just wanted to put that out there, that there are still, there's checks in place to ensure that the people accessing these are actually lawyers in good standing.
Not like a verification sort of thing.
Yes.
Right. And, yeah, thank you. Yeah, that does provide good background, because if you see in subsection E, what the proposal is to say, okay, remember, we just said subsection A said, well, okay, generally speaking, court cannot permit public access to the internet to criminal, family, probate case records. You then say in subsection B, so you make a qualification for that. Say, all right, that may be true for the general public, but this says, but licensed Vermont attorneys in good standing shall be provided access via the internet through the internet, through the judiciary's public portal website or other way. So in other words, it leaves the court with some discretion about how to do this. It doesn't say how you got it, just says do it somehow.
Yeah, are there any parameters around that attorney actually having a reason to access those cases? I mean, I'm able to access medical records, but only if they're pertinent to the cases I'm working on. I can't just access anyone's medical record. And I'm wondering if there are any provisions in here around that same sort of, it can't just be any attorney, because I feel like oh, I'm an attorney and I want to see if my ex-wife has has records in Odyssey. Like, I have to actually have a professional reason to access it. Does that make sense?
Yeah, and my understanding is you probably want to hear from the chair of the court users group would have more information about that. But my understanding is that there are ethical considerations around whether an attorney can do that, and that, for example, the attorney all this does is make it what they can do remotely. Whatever, it doesn't change. Like, they could go to the courthouse terminal and do exactly what you just said. Still guided and ruled by the ethical rules that apply to them. I.e., just searching randomly to some other case that doesn't have anything to do with anything that they have business with. So that applies. But that what they could access physically in person, this proposes to say they can also access from their office or home.
Which makes sense to me, but if we're discovering that maybe there's a space that needs strengthening while we expand that, I think it's worth considering.
Yeah.
Like, I certainly get that this is just offering the remote access to what they can currently
Sure.
access physically. I guess my question is, would they be able to access
Right. Yeah.
some of those things at all without any guardrails,
And there are guardrails.
legal
No.
guardrails?
Yes, there are licensure guardrails. If you are doing things that are unethical and in violation of the rules and regs, for Vermont attorneys, you can get disciplined, you can get suspended, you need some license. But, at the same time, same records, literally anybody can access them still. For whatever reason, even if they do just want to be nosy, they just have to physically go to the courthouse.
Right.
But attorneys, whether they're accessing them from the courthouse or their office, still have to follow the ethical guidelines that regulate the profession.
Yeah, I agree with that. So that's really the proposal there. It doesn't kind of add anything more substantively to it. And you'll see that yeah, that's right. There are some existing tax carve-outs to see that as well. So section C, not really developed here, but there are other carve-outs for that non-public access piece as well. So I can move on, then there's some more questions on that section. So the sections 22 and 23 are related, and this has to do with the public inebriates language, which you may recall has come up a number of times over the years in this committee. And this basically, right now, public inebriation can be a reason for someone being incarcerated at the EOC facility. That's the existing state law. But there's always been this language that has been put off several times over the years that says, and this is the language that in parentheses on lines 15, 17 that's being referred to, that prohibits someone from being incarcerated solely because of public inebriation. Right? But it has never gone into effect. It's always had this, and the effective date has been bumped up and been bumped up and bumped up several times over the years.
For layman's terms, like drop date.
I don't know exactly. I think it's maybe a way to understand it.
Yeah.
I think that's the
Just trying to put it in the light terms.
Yeah, right. Yeah, I think that's the concept.
Okay, yeah, just want to make sure I was thinking about the right thing.
Yeah, solely for being debriefed. Okay. So the proposal here is actually what this was in H 411, I believe, which was the Governors of Public Safety Bill. And so the proposal is to, rather than keep putting that language off, deferring it by a year, 2 years, 3 years, or whatever, each time, just repeat it. So that, rather than having this language hanging out there that would eventually prohibit people from being incarcerated solely for public inebriation, just repeal this so that, the inebriates could be incarcerated.
Did you happen to know if there are any other bills that already have this? Because I've seen that Representative Emmons, I believe yesterday, had suggested that it might be in a House bill.
There's two things I've heard about that. Yes, it is kicking around a couple of other places. As far as I know, in the House, on the House side, the talk had been including it in the House amendment to this bill. So that's, wouldn't have to be done. So or you could do it that way. You could just say, well, let them deal with it. That's an option too.
Well, I mean, it's already in there, so we'll just carry on with it.
Yeah, and I think just to add one more thing so I don't forget. I also heard potentially, maybe you want to follow up with Senator Lyons on this, that there was a potential that it was going to be included in some Senate Health and Welfare Committee bill as well. So I don't think that's fine.
Senator Norris and Senator Bowles.
Yes, just to follow up on Senator Mott's opening question. The joint pain versus protective custody is what's referred to. Generally speaking, when someone is inebriated and at a danger to themselves, can't find screening for their protection, presumably seem to be losing a lot of them throughout the state of Vermont right now, just because staffing issue, not necessarily money issue. There's still a process where they're screened at the hospital. And then every attempt is made to release the individuals to a responsible individual who is non-intoxicated. In fact, if they can't find that option, then they have to bring them to the correctional facility for their own safety, what it amounts to safety. But yes, that's what it's
Helpful, thank you.
Senator Bowles.
So under current law, they can't do that? I'm just trying to understand the purpose of this.
No, under current law, they can. But there's this provision that they can't, that's always been, that has been, on the books with a deferred effective date. It's never gone into effect. But it was many years ago, it was first passed. I don't have the exact numbers, but you passed the provision, the legislature passed this provision many years ago, that said, you can't do that, but we're not going to put it into effect. It's like they were kind of giving them time to figure out some other alternative, but that's never happened. So the legislature has kept deferring that date, pushing it out by a couple years at a time.
Familiar?
Yes. Excuse me.
Because I actually have significant concern using our correctional facilities to treat people who are intoxicated, and there's a concern that they may harm themselves. I don't think that is the purpose of our carceral system, so.
But this is for an operator. Yeah, the general population. So it's the legislature in the booking area where they have 24/7 eyes on the shelves.
Right.
My understanding, it's been a very long time since I've actually used this person. This is exclusively, as far as I'm aware, people who are extremely drunk and they're transported. They basically spend the night there. And then once they blow, I think it was either they blow under an 08 or they have to blow zeros, then they're released. It has, I can't remember the exact language, but it was people who were either above a 0.3 or people who literally couldn't stand up. And, they're not going to the hospital. If they didn't have a family member or a friend to take care of them.
It's a last ditch effort, shall we say, at the treatment facilities. It's they have to get below 0.08, so they can release at the correction facility if they have to go observe across the board.
Yeah, I feel like it's safer than leaving somebody to sleep on a bench in the middle of winter or something, but it's like, well,
I hear you. It just brings up the larger concern for me that we're using our jail system to treat healthcare issues. Like I have a bigger systemic concern with this.
And then there's the alternative.
I think we would be investing in the alternatives. And just continuing to defer something and not doing the work to change the system doesn't seem acceptable to me.
please carry on. Like, there's anything further.
Right, so as I said, both sections 22 and 23 propose to eliminate that, or to repeal that language, repeal the deferred effective date. Section 24 will look familiar to you. This is the zip guns, the switchblade knives bill that the committee already discussed. And this was proposed to be set. Here, remember, the issue of the currently possession of what's known as the language is on the line, section 7, line 3. Switchblade knife, possession of a switchblade knife, blade which is 3 inches or more in length, subject to a criminal penalty. The issue with that is that the law does not define a switchblade knife, so that I remember the committee's discussion. I wasn't actually here. I think Attorney Michael agreed tomorrow as we covered that issue, but I think the issue is that there's no definition of switchblade knife in the law, so that any kind of automatic opening knife that was longer than or 3 inches or more in length could conceivably be subject to a criminal penalty. So the proposal in the bill anyway was to strike that language, so that zip guns would be prohibited, but it wouldn't apply to switchblade knives anymore. It just occurs to me this is from the bill that probably, if you choose to go ahead with this, the typo would be you want to strike the switchblade knives language from the title of the section as well, if you decide to do that.
Eric, do you have any sense of when the last time someone was charged under this statute was?
No, it's a good question. Good enough. Yeah.
I'd love to know the answer.
Right.
If I can find it.
Yeah, you might, that would be, I think that the Center for Justice Research probably could answer that question.
Should there be an amendment in which any records that exist of somebody who has been charged with this gets expunged automatically?
I would certainly be open to that. I just want to know when it's been used, if it's being used, just a little bit more background information about this.
Yeah, maybe.
Probably right after West Side Story.
Well, I'd love to
Which one are you
know
referring
actual data and not anecdote.
Which one are you referring to, the note or the switchblade?
Well, I don't know, because there's no definition.
Well, no, she was asking what was charged. You asking about.
I mean, switchblade piece is the piece I'm particularly interested in. If we're getting rid of it in the law, I'd like to know the data around it.
I don't know this for sure, and but the person to ask would be Robin at the, I'm probably getting the name wrong. He used to be the Center for Justice Research Program. I'm sure he's in part.
Crime research group.
Yes, they know, right. And I don't know. Sometimes they'll they can come up with a number of charges under a statute, whether or not they'd be able to distinguish between whether it was a zip gun or a switchblade knife. I don't know, actually question.
Yeah, I'm just curious. I mean, if
Yeah.
they come back and say that, the last time this statute was used to charge anyone was in, 1962, I feel pretty comfortable getting rid of it.
Right.
And of course, including automatic expungement.
Anything else in this last section before we go to our next witness? Thank you. Oh, yeah.
One more topic. Sorry, yeah. So going back to the bill. So this involves section. Let's see. Yeah, okay, so section 10, which starts on page 6, goes over on to page 7. This is the issue. You may remember, this is when I got to talk about the word polling with respect to statute of limitations. This is the issue where there's an inconsistency between two different statutes of limitations that are on the books for claims against the decedent's estate, claims against an estate after somebody dies. Right? So one provision, which is in the decedent's estate law, Title 14, which you're looking at, section 10.
Did you say page 10?
I'm sorry, section 10, page 6.
Okay, I was like, because page 10 appears to be about human trafficking, so.
Oh, yes, unrelated topic. Yes, section 10,
Thank
page
you.
6. No, thank you. So the existing statute that is reprinted right there in Title 14, which is decedents estates, you know, the law when people pass away, the wills and that sort of thing. And that's on line 20, if you look at line 20 of that page. That has a 1-year statute of limitations after the person passes. So if you got someone dies, you got 1 year in which to file a lawsuit or a claim against the estate. However, there's a separate section of law which is not reprinted right here, but that's over. Look at page 7, line 4. It's referred to. That's in Title 12, the Court Procedure Statute, section 557, which says, hey, when a person dies, against whom a claim could be brought, there's a different period of time that applies, and that says that when a person dies, the statute of limitation pauses, which means pauses until an estate is open, and then once the estate is open, then you get 2 years to file a claim. So they're different, right? Question: well, we got these inconsistent statutes on the books. What do we do? So I sent that out to Judge Kilgore, who forwarded a number of other probate judges and what to do about this. Heard from the Bar Association as well, and there's different points of view about what should be done. I think everyone agrees that there's an inconsistency here. It doesn't come up very often, which is fortunate. That's going every now and then. And you know, some people say that, well, on the one hand, there's this provision that the reason that possibly this exists in the probate law is that you have this certainty of 1 year, right? And then when somebody passes away, there should be a time when the estate can say, all right, we're free of any claims now. It's all done. That's the way it happens. It doesn't have to be 1 year, but it is 1 year existing. On the other hand, and so that's sort of definitiveness and to be certain about the end of the person's estate. They can close it up after they die and know that, hey, there aren't going to be any more claims. On the other hand, there's the point that, well, usually if there's a personal injury action, for example, you have 3 years, and wouldn't maybe somebody who was injured possibly be surprised to learn that there's this other shorter statute of limitations on the books, and why don't they get their 3-year period? So there's legitimate points of view on both sides of this, and one possibility. So, question is like what to do, right? So you got to, there's a number of options that you might think of. You could one possibility that came to mind, which I floated to both the probate judges and the Bar Association, is would you folks want to work on this for the next, interim, and possibly come up with a resolution for how to make these 2 different statutes consistent, or choose a way to go and make a recommendation to the legislature for next year. So that's one option. Extract this section, put in that. You could also narrow it. You could, so over on lines 3 and 4, page 7, for example, right now, the way it's written, the rate's written now basically says the 3-year statute of limitations, the one that's not 3 years, 2 years after the estate is, that one trumps. So that's the one that governs. That's the way you've written out this. This section should not be construed to affect the period of time limitations of applicable to claim under the probate estate 557. So that's saying that's the one that governs. Could do that if you felt as a policy matter that you prefer the longer period of time for the person. You could do it that way. Or you could maybe narrow that down a little bit. You could say, well, what we're really concerned about, because I think where this originated from was, if I remember correctly, a practicing attorney who can't come up in a case involving a particular fatality. So you could narrow it and say, like, this section should not, be limited to, say, personal injury, personal property injury kind of cases. In those kind of cases, if that's the type of claim, then we're going to stick with the longer view limitations. Anything else, fine. You can just go with your regular, shorter 1 year one. I could draft it that way too.
There's a part of me that thinks perhaps this section needs additional time, some more due diligence. I thought initially perhaps it would be something that would be an easy fix, but from what I've heard from different angles, I think there's more to it. And it's not something that I want to run through if it's not a catastrophic issue that needs to be fixed promptly. So my feeling at the moment is to put a pin in it for now. If we hear otherwise in the next 24 hours, maybe we should come back to it, but that's my initial thought. Any.
I feel better about actually doing a little bit of a deeper dive in this. I've got some spaces that I've got questions about, so I would support that.
And maybe we can also mention it to the House and they can take a look. And, yeah, so that works.
Yep. And I could respond to the bar and permit if you want to just sort of give them the update that that's kind of what it looks like for now. But to the extent that you folks can work together and propose any way to kind of resolve this apparent inconsistency, I think we'd be happy to hear about it, something like that. All right, I think that's it. That's all that I had right now.
Thank you.
Yeah.
We have next up, we have Chris, and thank you to all the witnesses for your patience. Yeah, Chris, if you want to go ahead. Sure.
Morning, Mr. Chairman, committee members, for the record, Chris Delia, President, Vermont Bankers Association. I'll be very brief. We support the language that's being proposed by Liz Smith and Jim Knapp. This is quite similar to other changes that we've made in statute over the years when the title community identifies a challenge out there that they see in the land records. We often come to the legislature and ask for fixes, and I put that in this category. So we would ask you to support this language that's been proposed to you.
And we heard earlier about 15 years. I had an initial reaction to that perhaps it was too short, but we got some rationale as to why it was 15 years. Do you have an opinion on that time frame?
I'm comfortable with what Jen had explained to you, the 15-year time frame.
Thank you. Committee, any questions? Good, thank you. Thank you. Next up, we have Liz Smith.
Hi, thank you. My name is Liz Smith. I'm managing counsel with CADIC, also sometimes referred to in Vermont under the trade name VADIC. So thank you all for the opportunity to present this and for our testimony. I don't really have a whole lot to add. Jim certainly covered a lot of the basis in terms of sort of the history of the validating statute in Vermont and the additions that have been made over time to, effectively accommodate, buyers and sellers in the real estate market from avoiding some, pretty expensive fixes in the event that we didn't have this validating statute. For example, something to the effect of having to open up a probate estate for a grantor that didn't have a power of attorney of record. So it can become very problematic, time sensitive as well for the market. And so it certainly fits in with what we already have for the curative provisions, particularly under Section A. I think maybe the only thing that wasn't mentioned in more detail that I'll add is that, this is aligns with other states, in our region. Maine has a very similar statute that also tracks their own statutory statute of limitations. For Vermont, it's 15. For Connecticut, it's 15. And Connecticut has a very similar provision in their validating statute for this exact specific issue in terms of a missing power of attorney. As Jim mentioned, it's, they're usually very hard to find, if not impossible after that length of time, which I think reflects ultimately the risk at play, which is effectively none. It's almost like an administrative error where something, that was intended to be recorded in a recording package that was sent to the clerk ultimately got missed by human error. So I think that sort of summarizes the issue and the need for it. And again, I think Jim did a great job sort of fulfilling the history and the purpose here. So I don't have much more to add, but thank you all again for the opportunity to have this amendment reviewed.
Thank you. Committee, any questions or comments? Yeah. Thank you. Appreciate your testimony. Bob, were you here to testify on this topic too, or just saying it out? Great. I think so next we have Sarah Robinson for a different topic. Thanks for your patience and please thanks.
No problem. Thank you so much for having me. For the record, Sarah Robinson from the Vermont Network Against Domestic and Sexual Violence. And I am coming to you all this morning because I reached out to Chair Hashim with a request that the committee might consider including a recommendation from the Domestic Violence Fatality Review Commission recommendations in this year's miscellaneous judiciary bill. So I am coming to you with that idea, bringing forward some language for your consideration to decide whether this might be something that could be included in the bill that you've been discussing this morning. I've submitted to the committee a copy of the 2024 Domestic Violence Fatality Review Commission report, which was actually released in January of 2025. And just as a brief amount of background, the Domestic Violence Fatality Review Commission is an interdisciplinary body. It is housed in and staffed by the Attorney General's office. And that body annually looks at all of the homicides in the state and determines and tracks which of those homicides are domestic violence related. And keeps statistical information on those homicides, but also conducts in-depth reviews of 1 to 2 of those homicides per year. And the purpose of the reviews is really to identify where our systems are working and where there are gaps in responses to domestic violence to prevent future incidents and to prevent future homicides. So on page 13 of this year's report, which is posted on your committee webpage, the commission recommended that the legislature appoint a working group comprised of law enforcement leaders, representatives from the Judiciary, the Department of Corrections, and other stakeholders to look at and enhance compliance with legal firearm surrender orders. So currently, defendants in criminal cases and in final civil relief from abuse orders, so those that occur after a hearing, may be ordered as part of their court conditions to surrender firearms. And so this recommendation came from cases that the commission has reviewed where there have been legal firearm surrender orders, but the surrender order process was either incomplete or compliance with those orders wasn't monitored. And so the purpose is really to have a work group comprised of these stakeholders to look at how existing laws are being implemented and how to strengthen implementation. So it's not about expanding laws, but it's really about how do the laws that are on the books, how are they working? Are there tweaks that are needed just to ensure implementation of those existing laws? So in accordance with this recommendation, we submitted to the committee some potential proposed language to advance this recommendation, though it could certainly be simplified, clarified, or pared down even further. I know that you all are operating on some tight deadlines this week, but I would be happy to answer any questions that you might have about the recommendation or to hear the thoughts of committee members.
Thank you. Senator Ruth, I know this is something you've had brought to my attention. If you want to add anything?
I will add, I think anytime the word firearm appears in the bill, it's controversial, but I think this is the least controversial bill on this topic that I can imagine, because it's just asking people to sit down and look at existing law and work on implementation, more efficient implementation. So it's not breaking new ground or it's just seeking to, clear up confusions and inefficiencies. So, yeah.
When I read it over, it seems also to, with the goal of trying to create uniformity around it so that, you know, when a legal order does exist, and it involves firearms and the read that in the firearms or the seizure of firearms, that there's some sort of uniform process that law enforcement is following across the state instead of a piecemeal or patchwork process, which itself could be problematic. Yeah, that makes sense. So,
I am not opposed to this concept. I want to make clear. I just generally want to be thoughtful about creating new working groups when it's possible. There may be an existing working group that could do this work. So it's the question I have is there an existing group that we have, or is this so specialized in its scope that it really does need a new group?
It's a great question, Senator Vyhovsky. We discussed that at the Fatality Review Commission. And this really does bring together a unique group of people that this is really about just implementation of existing law. And I think that Senator Hashim, you stated it well, that we do have such a patchwork of agencies that have overlapping jurisdiction in various areas of the state. And so this is really about how the process works. We also felt like it was really important for us to pull in voices from federally licensed firearms dealers as part of that process. They play a very important role as it relates to firearm storage in Vermont, and have not been involved in previous conversations, and wanted to ensure that some of those voices were well represented in this group as well. So it really truly is a bit of a time limited and unique set of stakeholders that's proposed to be brought together here.
Great, thank you. If that makes sense to me, which is what I assumed, but I don't, they have lots of interesting sayings about assuming things. So thanks for answering the question.
maybe any further comments or questions? All right, so that wraps it up for the miscellaneous bill for now. We can come back and we've made some changes, right? So yeah, to come back, we'll walk through tomorrow. Would you be able to do the walk?
Yep.
Tomorrow?
Yep. But just so to clarify kind of what you'd like to see tomorrow, so we'll probably want to integrate, so we're looking at this as an amendment, maybe integrate everything into a strike all amendment, but
Yes.
makes sense, because we're gonna strike one of those section we mentioned on the statute of limitations, maybe add some language from that has just been mentioned from the Vice Chair Robinson, plus a few of the sections. So for now, if we could just add the sections that were, I think, that I went through in the amendment earlier, put those all into one group for now, and then maybe wanted to hear, it sounded like from the crime research group, so maybe that's someone Caleb will get in touch with them if they're available tomorrow on that.
What was it again? For
Whether this, how many prosecutions on this zip code switchblade knife statute section, whether they're
Well, can you bring specific section on it?
section, what's in the amendment, section 24,
Section 20.
page 3.
Thank you.
Yep.
potential options? Yep. And, okay, yeah, so we can have all of that done.
Yep.
Tomorrow.
Yep.
I'm gonna walk us through a point.
I would think it's
I was hoping to add the automatic expungement
If any effects.
if they exist.
Okay.
So they put it over now, and then
You may hopefully. Even though it's on that simultaneously, left for the team, but they still have.
Yep, right, thank you.
I don't know.
And as to F-45, I've been trying to get Mike O'Grady in to follow up on any changes that may have been made. He doesn't have access right now to the file because I think he's in Senate Natural Resources. So I think that we can either, shouldn't be a problem if we vote it out tomorrow. We can have those come in the event that it's not available tomorrow. And I would put us at Friday, but I think would be a problem. So if the committee had 5 minutes, 10 minutes to meet, perhaps we can do that. Sure.
The other possibility is we can vote a bill out and amend on the floor. Yeah. You know, get rid of the crossover problem that way.
Right. Okay. Good man. I would, any thoughts on that process? Just get it out behind us.
Okay, no one going.
All right, let's have a clean copy of it that we can vote on, take some questions. Okay, well, do we have a clean copy of S 45? Yeah, no problem.
This is sort of law enforcement. It seems to me law enforcement advising.
I'll have to think about. Think about. Yeah.
It's just the bill is introduced. It's,
I've
We're in
read
the NA,
Yep.
We've asked for.
Yeah, it's, right
the
there.
mediation.
it's just right here, and how many meetings, how many
Yeah, yeah.
members, less, if you get tons of times that already exists in here.
Right, but it's just.
Committee were there,
That would be.
aside from the mediation change. Still, aside from the mediation change that was discussed yesterday, were there any other changes that were proposed to S 45?
Couple of it on.
And so, okay, yeah, so we can vote it out as introduced and any changes to mediation can provide a floor amendment. This just, this gets the ball rolling. And any other changes that may have been missed that I can't recall at the moment can also be put into a floor amendment, but pretty sure it was only the mediation piece that we had any substantive conversation about. So this will also allow Senate Ag to wrap up their work and they can do so. That work. Right. Yeah, we can get a copy. I guess only Senator Forrest will need it. They're going to be able to serve it.
I'll write that down.
I have one, yeah. Thank you.
And you have,
What that? Yeah.
Any further discussion? I would entertain a motion to vote this out favorably.
I would move that S 25 voted out favorably as presented.
Any further discussion?
I mean, I just continue to share my concerns that this doesn't, especially without a change to the definitions, doesn't strike the balance needed, and so I can't support it. And it's not because I don't support our farmers, it's just because I don't think this is the appropriate balance.
And you're referring to the trespassing.
I'm referring to the trespassing piece, but I also would really like this committee to implore the agricultural committee to re-examine what is a farm. I think that $2,000 threshold in 2025 is way too low. It makes it way too easy for people to access in places where they shouldn't be necessarily accessing these protections.
Anything further? Good. Please call the roll.
Senator Norris,
Yes.
Senator Vihowski,
No,
Senator Baru,
Yes.
Senator Meadows, yes, Senator Sheen,
Yes.
410.
Does this have to be reported this week?
No.
Okay. So I don't have my summary from my son available, obviously. but-
No, we can pass over it on the floor. if we put it on today, it'll come up for action Friday. But we can pass over, yeah.
Do I make that motion or the chair make that? You'll make that.
Not a priority.
I got a lot of.
We can add onto the agenda, we go down, that's where.
Yeah, there's just, we'll be passing over a lot of stuff.
And we can,
People
we can
are
share.
stuff out there to be fixing it.
Thank you.